listen-only mode.
Well, hello everybody. Thank you for attending the session on the Michigan Library Privacy Act. I just wanted to let everybody know at the onset that I'm still accepting questions as we go, primarily because the Library Privacy Act, the law, compared to other seminars, if you've been to the other seminars or webinars that we've done, the law part of the Library Privacy Act is relatively I wouldn't say it's straightforward, but it's only a few slides. The Library Privacy Act itself is not very large, and the act itself is, I think, relatively straightforward. The problem comes with interpreting the act. Currently there's no litigation that I've been aware of that has been filed over the Library Privacy Act. So when we get questions from clients about application, we really have to look at things on a case-by-case basis. Also, for those who have attended seminars before, probably know that I don't spend a lot of time doing disclaimers, telling you that this isn't good, this isn't legal advice, and you should contact your own attorney. But in this case, I want to stress that a lot of the Library Privacy Act and what I do with our clients is it is often, like I said, a case-by-case analysis. And so there'll be points along the way where I'll tell you, certainly if you come across a situation like that, my recommendation is to contact your legal counsel contact your legal counsel to run over the issue with him or her to make sure that you're all on the same page. I have one note here, just a housekeeping, that it seems like at least one person doesn't have sound. I just wanted to make sure that that wasn't consistent with the group. So I guess if nobody responds back or sends me a letter saying they don't have sound, then I will, okay. Some people can hear me. Okay. All right. Well, I'll continue on, and hopefully the sound issue will be resolved for those of you who don't have it, or you can let me know whether it's still a problem. I want to spend the first part of the presentation going over the specific requirements of the Library Privacy Act. One of the first things that's important to know is, well, what is covered by the Library Privacy Act? There's a lot of confusion out there because I think part of education in the library world is to, strictly maintain the confidentiality of your patrons, and there's a general push to make sure that that patrons' rights are protected within the library, which is a good thing. But it's important to know that there are specific legal requirements, and that the Act specifically defines what is considered covered by this specific piece of legislation. Section 3.1 of the Act states that a library record.
Welcome to GoToWebinar Web Events. Welcome to GoToWebinar Web Events Made Easy.
To give out what is considered a library record to anyone, and certainly in response to a Freedom of Information Act request. As you can see, there's the first part of that statute. It says, except as provided in subsection 2, which we'll get to in a minute, a library record is not subject to disclosure. Well, what is a library record? And the statute has specifically defined what a library record is. It means a document, record, or other method of storing information retained by a library that contains information. One, that personally identifies a library patron, including the patron's name, address, and telephone number, or that identifies a person as having requested or obtained specific material from the library. So as you can see, a library record is actually a tangible document, a tangible record, and it is something that's actually maintained by the library.
Welcome to GoToWebinar Web Events Made Easy.
Library patron.
Welcome to GoToWebinar Web Events Made Easy.
Information, which is what people are reading and checking out of the library. Hang on one second, I'm having a slide problem here. Okay. A library record does not include non-identifying material that may be retained for the purpose of studying or evaluating the circulation of library materials in general. So what that says is that, you can release information to your patrons, to the public about, what your general circulation is, how many materials you have, how many materials have been checked out, as long as in the process you don't reveal anything personal about any particular patron or person who uses library materials or services. If you recall a few minutes ago, we talked about the definition of, we talked about the act that says a library record may not be given out in response to a FOIA request unless provided under subsection 2. Here's what subsection 2 says. Unless ordered by a court after giving the affected library notice of a request and an opportunity to be heard, a library or an employee or an agent of the library shall not release or disclose a library record or portion of a record to a person without the written consent of the person liable for payment or return of the materials identified in that library record. Basically, what this provision states is that you may not, see it says library shall not release, you are not to release any library record or portion of a library record to a person without the written consent of that person or unless ordered by a court. And what is proper court order? Here's where I start my disclaimers. This is something that you should specifically talk to your own lawyer about. It used to be my opinion that a court order was a order signed by a judge. So a subpoena certainly would fall under that. Certain types of federal subpoenas are signed by judges or magistrates. They would certainly fall under that. A search warrant, certainly. The problem I have lately is that the Library Privacy Act, I think one of the problems I have with it is that it doesn't define the term court order. And if you look at the Michigan rules of Michigan court rules, it defines a subpoena as an order of the court. And you know this because if anyone who's been involved with the court system or seen all those legal shows will know if you don't comply with the subpoena or the order to appear, you could be in contempt of court. It is an order of the court even though it's not signed by a judge. So I want to go back up to the slide before. So what do you do when you're faced with a subpoena, something that's not, if you're given a search warrant that's signed by a judge, some other type of record that's signed by a judge, I think it's pretty clear that that would be something that would comply with Section 2. So what do you do? What do you do if you receive a subpoena? My opinion is you first of all contact your attorney, and secondly, this may be an opportunity for you to request that notice and give an opportunity to be heard. I'll give you a scenario. Let's say that you receive a subpoena, and the subpoena is for library records. And often we get these types of subpoenas. They're not really. Some of them are law enforcement based, but a lot of these subpoenas tend to be subpoenas that really have nothing to do maybe with the operation of the library or the operation of law enforcement. For example, we've received subpoenas in the context of divorce actions or child custody actions. So you get a court order. And one of the things you may want to do is request that notice and hearing, because what will happen is one of two things typically. One is that if you contact the attorney that sent the subpoena, often that they will withdraw the subpoena because they don't, maybe they're on a fishing expedition or the documents are really that important. They don't want to spend the time and energy appearing before the judge. Secondly, if you do go before the judge under this subpoena, maybe you ask the court to quash the subpoena. Maybe you go in there more with an attitude of that the library is not really objecting to the release of material, but they just want the court to hear their side of the story and make sure that the subpoena is valid. And then at the end of that hearing, likely you'll get your order of the court. The judge will either order the library to comply with the subpoena, or the judge will order the library not to comply with the subpoena. But either way, you're going to end up with a court order that would, I guess, supplement the subpoena. But this is one of those issues that you're going to want to talk to your attorney about, because I think you're certainly going to likely need representation in such a hearing, and you may want their opinion on the definition of court order and how they view that. And here, again, we're talking about the hearing. As I mentioned before, the library does have an opportunity for a hearing. I want to pause here for a minute because I think that sometimes the Library Privacy Act doesn't really flow very well with actual practice. And oftentimes what happens is that here you have the statutory opportunity for a hearing given to the library, but you may be faced with police or a law enforcement agent showing up at your door with a search warrant. And as you know, a search warrant is immediately executable. And what that means is that if they show up at your door with a search warrant, it's an order of the court to allow you, the officers to immediately seize the records or whatever's in that search warrant. They may give you the opportunity to contact your lawyer to review the documents, but typically it's not required of them. As opposed to a subpoena, if you've received them before, you'll know that they typically give you, days, weeks, etc. to gather the documents and turn them over. So here you have a situation where you may be faced with a search warrant and you're given the opportunity for a hearing, but the statute doesn't really clearly say that the opportunity for a hearing would trump the fact that the search warrant is immediately executable. And so typically the library is faced with allowing the police enforcement agency to follow through with their search warrant and collect the documents and maybe have the opportunity later to talk to a judge about whether it was valid or not. But again, from the library's perspective, make sure that you understand that there is a statutory opportunity for a hearing, and whether or not you take that opportunity may depend on the specific situation. The statute also specifically says you may be represented by counsel at that hearing. Again, in my prior example with the subpoena, I gave you a couple things that you may want to address, the library's concerns if you have any with the subpoena. But one of the things that I want to specifically talk to you about is the scope of the request. If you receive let's say you receive a search warrant or a subpoena for all computer records on computer 1, on a particular day, on December 8th, 2011. And really what the law enforcement agency or somebody may be looking at would be the records of a particular person they were trying to investigate. Well, if the subpoena would take in far more records than is necessary for the particular investigation, then you may be able to convince the judge to limit the subpoena. For example, if the police know that the particular person they were interested in was only in the library from between 12 and 2, you may get the subpoena modified to only those particular 2 hours. Those would be something that you could talk to the judge about. The judge could review the issue and may revise the subpoena or issue an order accordingly. Again, this option may be easier to accomplish if the library is faced with a subpoena rather than a immediately executable search warrant. We've gotten some questions about the written waiver. As you'll notice from the previous slide, there's a lot of information in that that you cannot, again, there's a lot of repetition here, but I want to make it clear that a library or employee or an agent of the library shall not release or disclose a library record, one, without a court order or without the written consent of the person liable for payment or return of the materials identified in the record. Again, if you have the person, if for example, if it's my library card and I've given a waiver to another person to allow them to see my records, then the library would be allowed to give the material or the information out to the person that was identified in that written consent. You'll see here, this, as you know, likely it's mainly developed to assist parents in locating and returning child's materials. Interestingly, as you know, libraries charge fines for materials, and the fines are set up on typically on a contract basis. If you understand that part of the library circulation policy is that you check out material from the library, and if you don't return it on time, you pay a fine. It's a type of contract. Well, children 18 years of age or under don't have legal capacity to make a contract. So there's a couple issues there that this was meant to address. Again, I think this provision of the Library Privacy Act was amended after an Attorney General opinion which talked about a school library and whether they could get the assistance of the school, or a library, public library, whether they could get the assistance of a school in tracking down material that was checked out by students. Again, what this is and many libraries have it. Basically, if a child signs up for a library card, the parent takes responsibility for the payment and return of the material. And in such case, the library is free to release the information about the child's materials to the library, or to the parent. One of the things that has, I think, cropped up lately that's really, I think, sort of an interesting issue that we really have to go on a case-by-case basis with our clients is a lot of your online sign up for library cards. Some of this stuff is done online. Well, how do you sign the written consent? And there are, I think, ways to do that legally. We just have to make sure that you do it properly, because what you want to do is you want to be in a situation where basically, I think, and this is my opinion, a child cannot open an account without the parent being responsible for this payment or consent. And I believe that there's certainly ways you can do it virtually on your website, but that's one of those things that I would talk to your legal counsel about specifically. You know, how can you do this? You know, what do your materials look like? Because that's one of those things. I know that a lot of libraries are trying to go paperless, and they're trying to make sure that you know, things are done in a convenient, easy way for patrons. But we want to make sure that this waiver is still lawful and enforceable. One thing to caution is that the waiver is not limited to the parent-child situation. It could also be used when a spouse is picking up material. There are times, and this is kind of a theme throughout some of these webinars, where the law really, I think, is at odds with sometimes the mission of the library, and certainly a library's goal to have good customer service. And one of these things, I think, is with the spousal pickup. A lot of libraries do have a practice where, you know, if a person has a library card, you can come in, or they'll just allow a spouse to come pick up the library card, or a spouse to come pick up, for example, information that's on hold for another spouse without the library card. My recommendation is that you make sure that your policies and your waivers are in place, and reevaluate these types of policies. For example, if your policy is that you allow spouses to pick up materials for their spouse without the written consent, you got to be very careful of situations where this may be a problem. For example, you know, think of the worst case scenario. I always tell libraries, you know, what if you have a situation where, you know, one of the spouses is in a domestic violence situation or is contemplating a divorce, and they've come to the library to check out material, you know, on divorce or on how to deal with domestic violence. It's something that you have to be careful if you would allow the other spouse to just come and look at those records or pick up those materials on hold for the spouse. That might be something that you think about, these types of worst case scenarios, when you're evaluating these policies that you have. And in a few minutes, we're going to get into some specific question and answer section of some common policies, and where you may have some concerns on library privacy, when they may conflict with, I guess, for lack of a better word, good customer service. I'm going to spend a minute on the penalty section, because it's interesting. It was highlighted before in one of the slides that a librarian or agent or employee of the library which improperly releases information shall be liable to a person identified in the record that is improperly released or disclosed. And the person identified may bring a civil action for actual damages or $250 and reasonable attorney's fees and the cost for bringing the action. What I get very nervous about with this particular section is really the potential liability for employees. It says a library or agent or employee of the library shall be liable. I don't know why that was intended by the legislature, but it appears to me with the ors that a person could sue the library or the agent or the employee personally for, they may be personally liable to that person identified in the record for the improper release. So they, again, I just wanted to make sure everyone can still hear me. There's another comment that a separate person can't hear. So if there's further comments, let me know. I don't want to be talking to a blank audience here. But so an employee or an agent or another employee of the library which improperly releases that information. This is one of the arguments that I often give to police agencies because you know, sometimes in trying to do their job, they may try to exert some pressure on the library to just release certain information to the library or to the police department from the library. And one of the things you know, we want to be sure to protect our employees and agents because it's not just the library that may be on the hook for any fines. It could also be the employees specifically. One other thing we get a lot is, you know, because oftentimes, and we're going to talk about this when we get into the section about, you know, handling these types of issues with your respective police agencies. But one of the comments I get, because what happens is that typically I try to, I will talk to the police agency or have the library talk to the police agency and we'll send them a copy of the Library Privacy Act and explain to them what parameters we're working with. And on more than one occasion, I've had a police officer get to the penalty section and basically say to me something to the effect of, well, I'll just pay the $250 if the library gets sued. You know, we really need this information. It doesn't seem like a big deal, $250. Well, if you look at the slide, it's actual damages or $250, whichever is greater. You know, I think they put the statutory $250 in there because technically if you, you know, if I'm a patron of your library and you release my information and you've released, you know, to my neighbor that I read, you know, a book on, you know, by Dr. Seuss or something like that, you know, it really probably isn't much actual damage to my reputation. So probably the $250 statutory fine would be what the court would look at. The problem with you get to actual damages is I think when you get into a situation where the release of the information may be connected to something that would be considered detrimental to a person's reputation. For example, the information involves, you know, looking at maybe at child pornography at the library, looking at something like that. And again, we're going to get into that a little bit later. I think the libraries have to make a lot of practical, real-world decisions on, you know, weighing the interests of the library privacy versus these other interests. But I worry, really, again, it's more of a subsection of that. I worry about maybe some person who was misidentified or improperly identified. Because as you know, with the way that the media works is that the media spends a lot of time, a lot of attention on crimes that occur in libraries. And if they can name the person, they do name the person. And then, you know, maybe months later, if it's just, you know, found out that it wasn't the right person or they were misidentified, the newspapers don't spend a lot of time making those types of news stories shown. So especially in a situation where you have someone that maybe is not, you know, specifically caught there, maybe has been looking at things that are illegal on computers, and you know, you're looking through the internet history trying to decide who might have been, you know, working at that computer at the time. You can see where things may get a little bit you know, may get a little bit touchy and maybe a little bit risky from that, so there's more of a potential for actual damages. Also, I want to point out attorney's fees. I mean, you all know, working with attorneys, that, you know, attorneys charge for their time, and even if you are, you know, involved in a lawsuit and the damages are $250, you're going to have to spend attorney's fees defending yourself for the library. And so even if that person is right, you know, they maybe get the $250, but they may, you may have to pay your own lawyer plus pay their lawyer for bringing the lawsuit. So that's why I want you to be careful of this provision and careful not to just summarily dismiss this as a $250 violation and that would be it. I wanted you to be sensitive to it and take that into account when you're making what I think are often very difficult decisions sometimes on balancing, library privacy versus the interests of maybe your public patrons and the employees. This is where I want to get into a little bit of question and answer. So what I've given you, as you can see, those were the slides. That's what the law says. That's the pure black letter law and Library Privacy Act. And as you can see, it's not an extensive law. It doesn't have and like I said, there's been no lawsuits filed under it, which I think is a great thing for Michigan libraries. But at the same time, the lack of case law does not give us, or it prevents us from really seeing where courts would go if these issues were brought before the court. So I wanted to talk to you now about some of the common questions that we get or hear from libraries about library privacy. And I'll be paying attention to the question board, so there may be some slight pauses as I read your questions, and we'll certainly get to them. If I don't get to them during the session, we can certainly talk by email or phone afterwards, and I'm happy to discuss those with you. But one of the questions I get a lot, is it a violation of the Library Privacy Act to give the Friends of the Library a patron list to use in a campaign? This, I think, is a pretty straight, of any of them, it's a pretty straightforward answer. It is a violation of the Library Privacy Act to give the Friends of the Library the patron list. And going back to the first slide, you can see why. I guess the protection zone of library privacy really involves the library itself or its agents. So the Friends of the Library, in my opinion, would not be considered an agent of the library, especially in the circumstance of a campaign, where typically their role is a ballot question committee or in some other advocacy relationship with the library. But certainly do not give your Friends of the Library a patron address list. From a library privacy perspective, you should always treat the Friends of the Library like you would any other nonprofit, a corporation. For example, if the Boy Scouts of America or the local Rotary Club came to you and asked you for information, if you wouldn't give the information to those groups, the rule of thumb is don't give it to the Friends of the Library. What if the patron asks for the director's personnel file? Can we deny the request based on the Library Privacy Act? The answer to this question is no. The reason is again, going back, we're looking at the specific definition, but the definition of library record relates to information that personally identifies a library patron, including the patron's name, address, and telephone number. The library director and the library's employees, information about them are not under the protection of the Library Privacy Act. And I don't mean to digress further, but I think that when we talk about library privacy, we talk generally about library documents and what you have to keep safe and secure. And the Supreme Court has determined that personnel files of public employees, to the extent they cover material that's about the that particular employee's performance on the job, are not exempt from disclosure under the Michigan Freedom of Information Act. Certain things in that director's personnel file would be exempt. For example, the director's social security number, anything that would be an invasion of privacy, such as medical information or information that may be strictly related to that employee's private life, would likely be exempt from disclosure, but not because of the Library Privacy Act, because of specific exemptions set forth in the Michigan Freedom of Information Act. The Michigan Freedom of Information Act has a number of exemptions, I think about 26 of them as I recall, and so there may be certain exemptions that would apply, but not because of the Library Privacy Act. One of the questions, I witnessed a man committing a lewd act at a computer. Is it a violation of the library privacy to call the police and give them information? The information that, the answer to this question is, and I hate to use a lawyerly phrase that is often used, but it really depends. Depends on what information you're giving to the police. One thing that's important to note is that the Library Privacy Act involves library records, which are documents and other tangible items, okay? But so an employee's observation of what happened would not be covered by the Library Privacy Act. But there's oftentimes in a situation like this, in this scenario, where they are there may be intersected. For example, if you saw somebody doing something to the computer, okay, and you called the police and said, look, this is the behavior that I witnessed from this individual while he was using the computer. That in and of itself is not a violation of the Library Privacy Act. But if the police say, well, can you tell me this person's name? And the only reason you know that is because they signed an internet sign-up sheet, or they gave their their library card, or some other way of identifying that person because of a library record, then that name, and that information would be protected under the Library Privacy Act. This scenario comes up often, and it's a very frustrating situation for both the library and the police department, because we've often had to call up the police department and say, tell them that crime has been committed in the library. Basically ask for their assistance in resolving the problem, but then tell them that you're unable to give them certain information without that court order or waiver. And typically you're not going to get a written waiver from a person committing a lewd act at one of your computers. But with that said, so one of the things that I caution, and I'm going to take this opportunity, and I probably will take further opportunity, is to talk with your police agency ahead of time, because it's never good when you have a crisis situation to be discussing the Library Privacy Act and its requirements for the first time. If you have a good relationship with the police department, you may have already worked out a situation where they may already understand the Library Privacy Act. They may be more than willing to get that court order. But oftentimes we're educating the police officers on the Library Privacy Act during this type of crisis situation where there's been a crime committed and there's witnesses that are upset, and it's not the most ideal time to do that. One of the questions that was answered about the last slide about the personnel is, who are volunteers who are also patrons considered employees if information is requested about them? If you have a employee who's also a patron, I think it's one of those situations you should really contact your attorney and determine whether they're asking for documents that fall under the Library Privacy Act, a library record, or if it's something that's more employment related. That's an interesting question. We haven't had that yet, but I certainly think that would be one of those kind of interesting calls you'd have to make at the time and really determine what the purpose of the FOIA and the purpose of the Library Privacy Act. Sort of a general rule of thumb, again, it's something you should talk to your, knowing what the risks are under FOIA for not disclosing something. Again, if you disclose if you do not disclose something that's ultimately found by a court to be disclosable, you're also subject to fees under the Michigan Freedom of Information Act, including attorney's fees. So there are some risks, but I guess as a rule of thumb, if you feel that there's considerable interest at stake and that there's a good reason for the exemption, I mean, oftentimes the conservative answer is to deny the request and then see what happens, because once you give out the information, you can't get it back. And so it's one of those questions that if you're in doubt, contact your attorney to help you make the call. But consider the information at issue and how it's used by the library, whether it's a patron record or it's really an employee record, and then go from there. this is, I think, probably the most questions I get right now about the Library Privacy Act is footage from video surveillance cameras, and can you consider those to be library records? My, I guess, short answer is unless I'm told otherwise by a court, or if there's an Attorney General opinion or something coming out on this, my opinion at this point is that library surveillance cameras, the footage from library surveillance cameras would be considered a library record in most cases. Because the definition of library record is, going back to that third slide, it's this method of storing information that's retained by the library that contains information that personally identifies a library patron. Well, I think your face, your mugshot, for lack of a better term, is a way to personally identify you. It's kept by the library. It's a method of storing information kept by a library. One of the problems I have now, I had a library once that had such poor surveillance cameras that you couldn't make out my own mother on the screen. Well, then arguably you cannot identify that person. Then it may not be considered a library record. But if it's like anything else, if you're looking at that particular person, you can see who their face is. Then that surveillance footage would certainly be considered a library record. What if the video cameras are on the outside of the building? This is one, I think, honestly, this is one of the ones I'll just be, is the one I struggle with the most, because the video cameras are often, if you live in an area that maybe have some high crime outside the library, a lot of libraries have video cameras trained on the front entrance, for example, or on the parking lot, or on a bike rack, because maybe there's thefts that occur in those areas. If the video camera is pointed at the front door where patrons are coming in and out of the building, I still think that video surveillance camera would be considered a library record. If they're pointed at the parking lot where patrons are, getting in and out of their cars, yes, I still think the video surveillance camera could be a library record. Now, if you have a specific piece of footage where you can see someone comes in from, not from the library, comes in from a different area, moves into the screen, steals a bike, and moves out of the screen, I mean, I guess that's going to be a judgment call about whether that information personally identifies a library patron. I mean, what is the definition of a library patron? There's no legal definition in the Michigan law about what a patron is. Is it someone who comes on library property? Is it someone who has a library card? I mean, I think for my purposes, I take a pretty expansive view of what a patron is and go from there. One of the questions posed is that, a lot of times people want to use video surveillance camera footage for different purposes. One question we had is, can the security images be shared internally for identification purpose if a patron is banned? The answer to that question, in my opinion, is yes. The Library Privacy Act prevents you from revealing information to a third party. And think of the video surveillance cameras just the way you think of your circulation records. I mean, certainly if, the circulation clerks would have access to that. If a patron all of a sudden amasses, $200 of fines, maybe the people in the business office will get a copy of that record. Maybe it gets up to the library director. Certainly that information, I think, is easily recognized as something that can be shared internally within the employees of the library. And certainly, typically the library board is covered by the Library Privacy Act too, and anyone who would be considered an agent of the library. I want to be real careful about the agency issue. We're going to get into that a little bit later, but certainly within, if you have a video surveillance photo of a person that's been banned by the library, you can use that internally to make sure that person stays banned from the library or does not come in the library. But one of the issues that we get a lot is, how do you respond to questions about the police? Because oftentimes the police will come in and they'll say, we just got a report. Someone stole a bike from your from the library. They file a police report. We would like to look at your surveillance photos to see if the person can be seen. Well, in my opinion, that information is subject to the Library Privacy Act, and there's no authority to show that information to the police without a court order. And then one of the questions again was, what if someone were using the library computer to view something illegal, such as child pornography? This is an issue that I personally struggle with, because I guess I'll give a little personal opinion here. I think there should be some sort of exemption or some sort of carve-out in the Library Privacy Act to deal with some egregious behavior in the libraries. Felonies, things like child pornography. But as the law is currently written, there's no exemption from the Library Privacy Act or the requirements of the Library Privacy Act for crimes, including child pornography. So this is one that's very difficult to deal with, because in situations where we've worked with child pornography in the library, we've requested that court orders be given in order for that information to be released. I want to talk, I think, at this point about some of the struggles that you may have in the application of this, because as the lawyer to the library, I mean, my obligation will be to tell you what the legal requirements are and what your risks are. So I've already said before that, for example, surveillance footage is a library record and shouldn't be given out without a court order. And oftentimes if a bike is stolen and 3 days later it's reported to the police, and a week later the police come to you and they want the surveillance footage, I think under those circumstances, it's been a while, they can get, it's not, there's no life or death situation going on. Requesting the court order would be something that would be advisable. The issue that I struggle with, and I think I just would throw out there for you to think about, is, how would you handle a situation where, a child is abducted from the library, and, the parent comes to you, the child's missing, you figure out, you see the child being taken by another person, on video surveillance footage, and the police come to you. Again, there's a situation where you may be in a situation where you're weighing the risks of violating the Library Privacy Act versus the risks of a child's safety, your moral obligation, the safety and security of your employees, for example. Those are the situations where I think a lot of times libraries may be in a situation where they're evaluating the risks of a possible violation of the Library Privacy Act versus what do you do sort of with the real life situation that may involve, some safety, security, somebody's life. And those are the types of things that I think I'd caution you to think about and talk about with your legal counsel maybe before they happen, just to be sure. So again, what the purpose of this type of training activity is, and when we do these webinars, is for you to think about these situations before they happen, because in my experience they typically happen at 7 o'clock at night or on the weekend, and people are just wrapping up for the day, and you're trying to track down the chief of police and your lawyer and everybody, and to figure out how to handle a situation. So training in prior planning would be something that would be advisable. Another issue that I get this question a lot, okay, and especially in small communities where you've lived your whole life and you know everybody. Well, what if I know the patron's name because the person's my neighbor, not because she's a patron of, at the library? Can I release that information to others, including the police? Again, one of my questions really is, well, how do you know them? Do you know them because they're your cousin or because they grew up next door to you? That may be one issue. But if you know them because they're a frequent patron of the library, I think it's a little bit easier to make the call that, look, that's part of a library record and it shouldn't be released without that court order or the permission of that person. Again, I think I may have already, this was one of the questions presented you know, on our question sheet. But again, if there's a crime committed in the library, may I reveal the name of the alleged perpetrator or show the police surveillance tape without a court order? And the answer is, under the strict reading of the Library Privacy Act, there is no exemption for a crime. And I want to state at this point, we have a lot of, I've heard of a lot of circumstances where libraries make the distinction between providing a copy of the document versus showing the police the videotape. And in my personal opinion, I think there's no difference. I think there's no difference under the Library Privacy Act between allowing the police to view the tape without taking a copy with them versus actually giving them a copy. It's still allowing them to review a library record without a court order. One caveat to that is, you know, it's, again, we talk about kind of difficult conversations, and one of the difficult conversations that we have with the police is, you know, they'll come to you, again, take the stolen bike example, and they'll say to you, we got a report of a stolen bike. You know, the bike was stolen, you know, on December 8th between 1 and 2. Can we look at your video surveillance tapes to determine if we can see who took the bike? One of the things the library can do without violating the Library Privacy Act is basically let the police know whether they're wasting their time or not. If the video surveillance camera is trained on a particular part of the bike rack, and if the library reviews that and says, you know, and sees that there's no person that comes in, you know, they can't tell, the person wasn't in the frame of the surveillance camera, let's say, during that time period, I think it's fair to say to the police, and I always caution people, libraries, to say, look, feel free to get the court order, you know, we're not stopping you, but we've reviewed the tape, and I don't, you know, in our opinion, I don't think it's going to show what you wanted to show. Just to let them know that, you know, it may be a waste of their time if they're going to go wake up a judge to get a search warrant, for example, that they may not be getting what they're wanting. Again, not telling them specifically what is on the tape or who's on the tape, but maybe some hints as to whether, you know, it's worth their while to go in and get the search warrant. Again, I want to talk a little bit about here too. We brought up the difference between the personnel versus employee records, and with respect to the, I gave you the example with the personnel file. With respect to security cameras and with respect to computer records, I also want to make the distinction that you have to, you know, think about whose computer records they're asking and how it's used. If the police come in and they want you to give them the internet history of a computer that's solely used for an employee, and there's no patron records on that, then, you know, arguably that record would not fall within the Library Privacy Act. Again, if the surveillance tapes show employee conduct without revealing patron conduct, that may be a distinction you're able to make. But like I said, those are times a quick call to your lawyer to kind of discuss the facts of the case and weigh the options, I think, would be in the library's best interest. Oh, I think I already answered this question. What if an employee lets the police look at a document or surveillance tape? Is that a violation of the Act? Again, I think that they're protecting the record itself and not the form that the record's in. And I don't think you're going to escape the Library Privacy Act by allowing the police to just look at the document without getting a copy. It may not be helpful to them anyway. They may need a copy for evidentiary purposes. But again, reviewing the surveillance tape, I think, may get you in the same situation as you would if you actually gave them a copy. Here's another common scenario that I've seen. Our library allows patrons to pick up materials on hold. We have a shelf with the material and the patron's name is clearly visible. Is that practice a violation of the Library Privacy Act? In my opinion, it would be, because you're creating a record, the library record, that shows that a patron, you know, if there's a book on a shelf and it says Searink or Ann Searink specifically on the book, and everyone can see that, then I think that that would be a violation of the Library Privacy Act. Again, going back, and hopefully we sent out the slides ahead of time. Hopefully you have a copy ahead of you so you can see that on slide 3. It talks about a document that personally identifies a library patron and identifies a person as having requested or obtained specific library material. Again, this is one of those this is one of those situations that you do this practice so that patrons have the opportunity to come, pick up the material, go through your self-check, and they don't have to wait to talk to someone in the circulation department. They don't have to wait till you go back and pick it off the shelf. It's one of those things that you do because, you know, for the convenience of your patrons. But again, I think there's ways you can do it differently, maybe the last 4 digits of their library card number, something like that, where if I walk by and look at your shelf, I won't be able to say, oh, you know, my neighbor Susie Smith just checked out this book. You know, I would be able as a member of the public to know what other material people are checking out. It's also something to keep in mind too with your circulation department, and to be discreet, obviously, when they're at the desk and you know, talking about, you know, things with patrons, information, that the verbal discussions of that take place in a discreet way as well. The question is asked about a sign-up sheet for an event on the front desk open to the public is a violation of the Act. If I'm looking strictly at the Library Privacy Act, it shows a person having requested or obtained specific materials, including that services. I would count that as well from the library. It shows that they're a patron of the library. Now, are you going to get sued for that? I highly doubt it. But, you know, again, it's one of those things that think about what the event is. If the event is, you know, the children's, you know, a children's reading of Dr. Seuss, probably not a lot of, you know, privacy issues there. But, you know, if the event is something that maybe, you know, have, you know, I'm struggling to come up with an event, but, you know, maybe if it's a symposium on, you know, divorce or domestic violence, that could be, you know, and maybe that's a situation where you wouldn't have it, you know, out and open to the public. But, you know, the Library Privacy Act doesn't make these kind of distinctions, and therefore I think technically that sign-up sheet would be problematic. The question is, I think, going back to my example about having those books on hold. The question was, could patrons sign a waiver to allow the library to place books on hold? Absolutely. I mean, if you have a waiver that says, look, you know, this is our policy, by, you know, signing this sheet, this is what's going to happen. Absolutely, I think you could do that. Again, make sure that the wording of that waiver is correct, that it complies with the Library Privacy Act, to make sure that there's some way, and again, going through this with some clients on your electronic, you know, communication, but there's some way of storing it or making sure that it's understood that when that person, you know, signed up for the service, they signed that waiver. An employee witnesses a purse snatching in the parking lot. The thief jumped into his car and sped away. The employee copied down the license plate. Is it a violation of the Library Privacy Act to give the license plate number to the police? In my opinion, no. And I think this is a specific distinction, because the purpose of collecting that information had nothing to do with library or library service. It's not specifically a library record. Unlike a surveillance camera that's kept and maintained and paid for by the library, you know, the license plate is not the same. So if you have an employee that, you know, and that's why, you know, sometimes discussing these kind of minutiae of detail with your lawyer would is helpful, because in that case I think that the license plate is not a library record or fall under the name. I think we've had some follow-up questions about the patron placing books on hold, and one of the questions was, if the book's wrapped and only the name is visible but not the title, is the fact that the patron of the library is the fact that the patron is a patron of the library itself protected information? Again, in my opinion, yes, and specifically going back to the definition of the Library Privacy Act, states that the person identifies a patron, including the patron's name, address, and telephone number, and that was another question about whether their telephone numbers should be on display. I think any of that, you know, who they are, what their information is, I think that would fall under the protection of the Michigan Library Privacy Act. And again, you do the sign-up sheets so that the patrons don't have to stand in line at the circulation desk or have to do anything in particular. I know when I go to the library, I have my kids with me, and the faster I get in and get what they're done and get the books, they love to check out the books themselves and get out. And I understand that it's convenient and you want to do those things, but sometimes you have to take a step back and at least think about what you're doing and think about it in the privacy of in the context of Library Privacy Act. You may decide that putting a sign-up sheet, saying that you're going to attend a library function, that the convenience and the of that and the privacy interests in that are minimal, and that they outweigh the risks of a violation of the Library Privacy Act. For example, it's kind of common sense that if I walk into a library, see a sign-up sheet there with sign my name to it, that I understand it's on public display. But again, I think if you're talking about the technical provisions of the Library Privacy Act, I think it could be a problem. But again, it might be one of those things that you have to evaluate within the context of your own personal library. Again, if it's a first name only and the materials on hold shelf, is that acceptable? I think, again, if you have, I'm trying to go through these situations, but if you have your first name there, let's just say your first name is like my husband's is John, and it says John, and you're going through, and then you have to go through and look at all these things. If there's any way that or just Ann, there's 5 other Anns that are placed on hold, if there's any way that I walk up to there and see that my neighbor Ann Smith checked out a book, if I can tell that, then I think it's considered a violation of the Library Privacy Act. So again, evaluate what you're doing, make sure that that it's impossible or virtually impossible to tell who requested that material. I think you're going to be okay. I want to spend a little time, we talked about the requirements of the Act, and we talked about some common scenarios that I get. One of the things I want to talk about a little bit, we've gone over it some, so I may have to skip over a little bit of it, is how to deal with police involvement. And as a separate matter, I want to talk about how you deal with library privacy when you're doing some internal enforcement procedures. Because as everybody knows, when you've got a patron issue at your library, there could be, you can ban a patron from the library without ever having to deal with the police. Sometimes the situation for which they're being banned is serious enough where you have the police involved and you also have your own internal procedures. So I want to talk about both those scenarios. One of the things I've previously mentioned is, and I'm going to kind of focus on this, is adopting procedures to follow when documents are requested by law enforcement. And again, I think this should be done, now or in advance of anything happening, so that people really know how to handle it. If you remember, 10 years ago now or so, when the Patriot Act came out, there was a lot of discussion on how you would handle a request from, under the Patriot Act. And libraries, attended seminars, and they had policies of how you handle it. And I think it's interesting because at that time I think there was a lot of focus on this, and there was a lot more attention to that. But what I thought was more interesting is that it's far more common that you would get a request from documents then and now from your local law enforcement than you would from, any federal agency under the, terms of the Patriot Act. And so I think it's still important to have procedures in place. They can deal with those Patriot Act requests, but they should also deal with your run-of-the-mill law enforcement actions. One of the things would be is to determine who would respond to the subpoena or the request. Figuring out who's in charge of the library. I mean, typically it's going to be the director, but as you all know, libraries are not open 40 hours a week from 9 to 5. They're open at different times. They're open on the weekends. and there's not going to be one single person who's always there, likely, to be in charge of the library. So you should develop a chain of command. You know, when the director's not there, it's the assistant director, and then so on and so forth. Really, the purpose of this is to make sure that the senior most person at the library is dealing with these types of requests, because certainly what you don't want is the you know, your brand new hire, you know, at the circulation desk, or, you know, the high school volunteer, you know, handling questions from the police. So everybody should understand who's in charge at any particular time, and develop that chain of command and educate staff at what that is. Who should be contacted? And, you know, a lot of the requests that we've been getting are for internet and computer records. And I think that this is, in that case, you know, if you have a request for you know, the circulation records, you know, that's going to be something that most of the people at the staff would be able to, you know, someone at the library at the time would probably be able to access that. You'd want to be able to have your attorney's contact information so that that senior person can contact the attorney if that's the desire of the library. Also, if you don't do your computer work in-house, or if your computer consultants are not on staff at all times, a way to contact those individuals should also be included in that information. Only because if you have a search warrant for that's immediately executable for records that are, you know, that someone at the library may not be able to obtain without the computer consultants, you need to have those people on staff that, and, you know, think of how you can get that information. More importantly, if the police walk in, let's just give you an example. If the police walk in and say, I want the computer internet history. It's 7 o'clock at night, okay? I want the history for computer 1, you know, from today. We suspect somebody was looking at child pornography. We want that information. If the practice of your library or the way your computers are set up, that the information is wiped from, you know, the libraries, you know, when you shut down the computer, all that information is deleted. You have an obligation to maintain that if you know a search warrant is coming. So you need to be able to figure out how to turn off that automatic deletion mechanism. Again, anyone who knows me, I'm not a computer person. I'm not very computer savvy. So you have to think about, you know, this may be easy for you to do. This would not be something I would ever know how to do. So you have to make sure that at any given time, that your library is open, that you may be able to have that information. Also, that information, as to anyone who was designated as in charge, you may also have the library director may also choose to give the cell phone to that person, or, you know, a specific board member may want to be contacted. I would caution that under the Michigan, or under the Patriot Act, sometimes there's gag orders in place that would prevent you from giving that information to anyone who's not immediately required to answer that. And so sometimes under those Patriot Act requests, you may not be able to notify board members, for example, even that the request has been made. But again, I'm talking right now about these sort of more common, you know, local police involvement where there's been crimes or, you know, attempted crimes at the library. The person in charge should understand how to access those records and how they're kept. Again, like I said before, are the records kept with an outside vendor? Do you need computer specialists to access those information? That's all things that you should be doing now and evaluating, so that again, what you're trying to do is prevent the stress of this crisis situation from impacting how you respond to these requests. Again, if the records, if you're anticipating a search warrant, you have to have a process for the preservation of evidence. You need to know how to preserve that evidence. The preservation of evidence is something that I think is taken out of the computer context for a minute, or the internet history, let's say. We we think that you should have a conversation with your local law enforcement about this, because I'll give you a hypothetical example. The police are going to be concerned about the chain of evidence, and they're going to be concerned about how the evidence has been secured. So what would happen, let's just say that the information they're looking for is actually stored locally on the hard drive of the computer, okay? So you have a laptop, or you have a CPU or something like that that's a tangible piece of hardware at the library that has the information they're looking for, but the library is waiting for the search warrant. The police may say to you, we're going to take that laptop and put it in our evidence room so that we know the preservation of evidence is chained until we get the search warrant. My recommendation is not to allow that. And what we've done successfully with some agencies is to say, look, for example, have your officer come over, and they came over and they wrapped up the laptop in their proper evidence, with the tape and everything on it, and we locked it in the director's office. And so when the search warrant came, we gave them the laptop that had been preserved in a way that they were comfortable with to maintain the chain of command. So it's one of those things that we were able to work out on the spot, but there was some back and forth, and there was some frustration on the part of the police department. So anything that you can do in advance to prevent those discussions from having to take place at these crisis situations is always advisable. One thing to do if the police are coming, if you don't know who they are, certainly ask for identifying information and make sure you have that contact information. And what if it's a verbal request? Again, you need a court order, and a verbal request from a police officer doesn't constitute a court order. So they may come in and want you to basically waive the rights and just give them the information without the court order. One thing I wanted to talk about here is that when you talk about library privacy, you want to understand sort of the difference that you are in versus like a private company. And I'm a big fan of Law and Order. I watch a lot of Law and Order, and you kind of see a common theme on some of these shows where, for example, the police will come into a bank or to a business and say, please give us a copy of all your receipts from today, or a copy of this person's record. And you always have a situation where there's, the brave employee stands up to the police and says, no, I can't give you that information, that's private. And the next step typically in these scenes is the police will say something like, well, we're going to shut down your business for today, or we're going to have the police come and do a forensic analysis of all your computers, and you're going to lose all this money if we have to do this. And then typically this brave employee ends up giving them the information, or showing them the, turning the computer screen so they can see it. The important thing to understand here is that this is a statutory privacy right given to the patron. The library doesn't have a legal right or ability to waive that privacy right. So, for example, if you have a situation like that, where a private business may be able to, turn over its slips. There's no right to privacy, for example, for clothes you buy at Macy's, for example. They may be able to give some of that information out without violating the law, but this is a little bit different. You don't have that right, and I think that the police should understand that it's not your, your right to waive. Again, when we're talking about procedure, we've covered this a little bit, but if the officer actually gives you the court order, one of the things that I recommend is that you allow to send a copy to the library's attorney prior to the execution order. You may or may not have this opportunity. Typically, the police have been, we know it's coming, they've been very gracious enough to allow us to look at it. But if you don't have that, ability, I think what you need to do is to look at the subpoena or the court order and use your best judgment. Make sure it's actually signed. I think, not in the context of a library, but one of the big, I think, telecom companies got in, or AOL got into some hot water about this because they complied with a court order, but the judge never actually signed it. So make sure it's actually signed. And this is something that I experienced once where we had requested that a police agency give us a search warrant before we turned over, a court order before we turned over some library records. And I got a copy of the court order, and it looked very funny to me. There was a caption on it, but it was really captioned to a non-existent case. It wasn't really a valid order in any way. And when I followed up with the police agency, they basically said, well, you wanted a piece of paper, so we gave you a piece of paper. Well, if it's a piece of paper that doesn't have any force of law, that's something that you need to keep in mind. You're not a lawyer. I actually give these to one of our criminal lawyers to look at just to double check to make sure. So, I mean, we understand you're not a lawyer. You might not be able to know the ins and outs, but, make sure it's signed, look at what it covers, and make sure that they only take what's actually covered in the search warrant. Also, keep notes on what they're taking and seizing, and then keep track of all costs. You may be able to recoup some of that. One of the things that I think is sort of very difficult for some libraries is if you're in a larger library system and you have, 50, 100 computers and they take one, it really doesn't probably impact your business. But, sometimes we've been involved in cases where they've seized, one of a small number of computers, and it really affects the way that the library does business. So keeping information on who seized it and when it was seized, and keeping in constant contact with the police agency to make sure that it's returned when, feasibly possible, I think is an important part of the process too. Typically, when you have a police involvement, you may also be contacted with the media. So. By the media. Therefore, we also recommend the library adopt or review their media policy. What the media policy typically has is that the library, one or only the director or the board president, for example, is authorized to talk to the media. And the reason you want to do this is, again, we talk about having the person in charge respond to these requests and having the senior people involved. And the reason you want to do this is that the senior people tend to be the people most educated on this issue and the most attuned to it. So you don't want, every employee authorized to talk to the media. They may accidentally slip up and release the person's name or release some other information that should be protected under the Library Privacy Act. So as part of the process, we recommend that you look at your media policy and also review your FOIA policy. The FOIA policy typically for libraries, you don't need a FOIA policy in order to respond to a FOIA request about Library Privacy Act issues, but it's often another good place to reinforce that the library is going to deny information under FOIA that's exempt under the Michigan Library Privacy Act. Finally, I wanted to talk to you a little bit about your internal enforcement and appeals procedure, because if you've listen to our sessions on patron behavior and meeting room policies, for example, we tell you that there's an important enforcement mechanism, and one of the things that's required by law for a due process in not only in Michigan but in the United States is that you have notice and an opportunity to be heard when you are banned from the library. Okay, so let's just say that you have a patron that's been banned from the library. And they're banned from the library because, let's just say something, egregious. They expose themselves in the library. Okay, so they're banned, and they're banned for something that could be considered embarrassing for people. Okay, so you have a situation where that patron then goes to your library board and wants an appeal of the library's decision to ban. One of the things that we want to caution you about is to keep the Library Privacy Act in mind when you're dealing with those issues. What we recommend is that you do not list that patron's name in the minutes of the meeting. We often will on the agenda in the minutes, label it Patron Appeal, 2001-1, and you are allowed to go into closed session under the Open Meetings Act to discuss information that's exempt by statute. And any library record, as we said, would be exempt by statute. And reports, incident reports, and letters informing patrons that they're banned are library records under the Michigan Library Privacy Act. Therefore, they can be discussed in closed session. Maintaining the confidentiality in this situation will lessen the risk of a defamation claim, especially if the person is ultimately found to, maybe it's a case of mistaken identity, or the board decided they really didn't do what they, what was, they were accused of. There could be situations like that where you want to make sure you maintain the confidentiality, because often when you have a situation like this, you have a person claiming defamation. Their character's been, smeared in the community. So if you can say to them, which we've had in certain situations where we could say to that person at the court, look, I know you say that we've defamed you, but if you look at the record, we've never named you. That patron goes to the paper and complains about what the library has done. So information like that, consider that. I don't know how many patron appeals you get. I don't think they're very common. So if you get one, from the beginning, think about how the Library Privacy Act impacts that that appeal, and make sure that you consulted with your attorney on the proper way to handle that, because again, you have this due process right to appeal their suspension to the library board. The library board meets in open meetings, and you have a real, I think, clash between library privacy and the public's right to know that is covered under the law. Like I said, the Michigan Open Meetings Act allows you to discuss information exempted by statute in a closed session. But again, you want to make sure that you're that maintaining the confidentiality and reducing the risk of any sort of defamation or other claim against the library for violation of the Library Privacy Act. So again, approving the minutes without specifically identifying the patron would be ideal. Finally, part of this whole enforcement appeal, again, is staff training. It's important for staff to understand the policies and the training, and making sure that they understand the implications of the Library Privacy Act, because I think like I said, a lot of these library privacy issues come up in crisis situations where people are trying to handle maybe an immediate situation. I'll give you an example. We've had situations involving child pornography. I mean, the crime is so egregious, and it's very, you've had, a staff member that may have witnessed, for example, some very disturbing images. You want to make sure that the training and the background is there, so that in that instant, the training will kick in. This is what we have to do. This is who we have to contact. This is the information that we need from the police in order to give you that information, so that you have a tendency to I think try to manage the crisis instead of try to step back and think of what's the appropriate thing under the Library Privacy Act. But again, I'm going to stress this again at the end of the session. If you have any questions, I'm happy to answer that. But one of the things I want to talk to you about, I mentioned this previously, is that we often, when I get a call from a client about a Library Privacy Act issue, we often go through a long kind of process, and we weigh, what's the situation, what are the facts, what are the risks, what are the risks of not violating the Library Privacy Act, how big is the risk of violating the Library Privacy Act, and then make a decision accordingly. You may want to also educate your board about these issues, that there may be some times where you're asked to make kind of judgment calls on the spot, and just maybe inform the board that there's this issue out there, and that everybody in the library is being trained to address it, and reduce the risk of unintentional violations of the Library Privacy Act. So with that, I have I guess ended the formal part of this. There's a couple more questions that I will answer, so let me pause a second to do the police need to give you time to read the subpoena before they start gathering the information listed in the document? The subpoena is a little bit different. A subpoena, just to clarify the issue, okay, a subpoena is typically signed by an officer of the court. It may be signed by a lawyer. It may be signed by a member of law enforcement. A subpoena is not necessarily signed by a judge. If you get a subpoena in the subpoena, it will tell you when you have to respond to the subpoena. And typically, they have to give you reasonable time to start gathering the documents. So in that case, certainly you will be given the opportunity to review the subpoena and gather the information listed in the document. Separately, police can come to the library with a search warrant. And a search warrant is immediately executable. You know, and I don't know whether they have to technically give you the time to read the subpoena. I think as a matter of practice that you're given the opportunity to read it. In my experience, again, this is just, you know, based on the 10 years or so that I've been doing this, typically the library knows it's coming and knows what they're going to be asked for. Typically, you know, as the attorney, I've been involved with the process with the police. So it really, I haven't had a situation yet, and maybe other members of the community can share their experiences if it's different. I really haven't had a situation as a practical experience where, you know, what you kind of see on these police shows where the police show up, knock at the door, and they just start kind of ransacking the place. I mean, it hasn't been my experience, but technically they can if they have a proper search warrant, they can gather that information right away. Question about the Library Privacy Act and children. Can we reveal the items they have checked out to their parents? This gets back to the provision of the Library Privacy Act that states that you cannot, okay, unless ordered by a court, okay, you can't give out the information. Unless there's written consent of the person liable for payment or return of the materials. So if a parent has signed a document that says they will be responsible for the payment and return of their child's materials, the library can reveal the items they have checked out. If the library does not have that written consent, then you cannot reveal that information. I just want to kind of go over the way that this is worded just for a second, because what I think they were attempting to get at is, I mentioned before that children under 18 don't have the ability to contract, so it wouldn't make sense that a person, that a child could, you know, sign their, you know, 5-year-old handscript that, you know, I allow my mommy to look at my materials. So the reason I believe it's worded this way is so that the parent who would, you know, typically, not always, but typically be 18 years of age or older, could get that written consent for the, you know, say, I'm going to take responsibility for the payment and return of this material, so, you know, you can give me the information. What's kind of interesting, I think, about this is take it out of the child context, which it was clearly designed to do, but put it back into the adult context. It really says that, you know, the way it's worded, if you look at that slide, it says the written consent of the person liable for payment and return of the materials. I mean, what, from a pure, you know, perspective of looking at the definition, what would stop me from, you know, coming to the library and saying, well, I want to be responsible for the payment and return of my sister's materials, who's, you know, 38 years old, and signing a waiver? Would then the library be able to give me the documents? I think that would be something that would be very hard to enforce. But again, I think the way it's worded was to get at the fact that, you know, someone who has the ability to sign that document is able to, you know, give the consent so that the library can release that information to the parents for children. With Kindle downloads at the library, Amazon will know what patron checks out on their Kindle. How is that affected by the Library Privacy Act? You know, that's an interesting question. I haven't had that before. It would be, I'd have to take a look. This is one of those situations we have to take a look at how those documents are handled by the library and what information the library actually has. But that's one of those questions I'd certainly run by your attorney. Can it just be a library policy that financially responsible adults have checked out can it just be a library policy that financial responsibility adults can have access to their items checked out? I think what they're asking is that can the libraries have a policy that says that parents are responsible for the items their kids check out? My recommendation is that you not just have a policy, that you have something signed or virtually signed, for lack of a better term, by the parent, because it says written consent in the Library Privacy Act, and I think notification in the policy may not cut it. Again, this is one of those situations where there's been no law on it, there's been no challenge to this, it's hard to know what the courts would do, but I suspect they'd want some sort of written consent at the time. Collection agencies, how does that apply to the situation? This is one of those situations that it's a little bit interesting, but I certainly think it would be safe to take the opinion that the collection agency would be an agent of the library for the purposes of collection of those materials, okay? But I guess in my experience and in my opinion, part of that contract with the collection agency, and they may have formed contracts, it may be something you either have to do separately with them or work it into the contract, but would be a provision that is the understanding that for the purposes of their doing, they're an agent to the library, and that they may not, you know, give that material out to anybody else, and they basically have to step in the shoes of the library, for lack of a better term, for the purposes of the Library Privacy Act, and not reveal that information to anyone else. Again, that's something that I talked to your lawyer about, making sure that that language is in there, and making sure that they don't have a concern about that sort of agency relationship. Well, I don't have any more questions, and it's approaching 2:30, so thank you again for your patience. And if you have any follow-up questions or you know, concerns, or if there's, we're going to send out an email that gives a link to this, and if other members of your library or board members listen to it and have follow-up questions, you have my email address. Just give me an email. Sometimes I could get to it right away. Sometimes it may take a little while, so I apologize for your patience, and always feel free to re-email me if you email me something I haven't received or haven't responded to. So certainly thank you for your patience. Thank you for listening. And one other thing, we're going to be having an employment session soon, but I would certainly consider doing these webinars again next year. So if there's any topics or that you think would be good for a webinar, if you have suggestions, again, please feel free to call, because we enjoy doing them here at Foster